And it's time for another installment of Martial Law with Marshall Chriswell. Our conversation brought to you here this morning at this snowy day, and this radio program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts. Different jurisdictions have different laws and regulations, and because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. That's Marshall Chriswell. Good morning.
Good morning.
It's good to have you with us here today. I trust you slipped and slid your way into work.
A little bit, yeah. Those are some big snowflakes out there.
Yeah, it's switched from the driving fine stuff into the big fat ones right now. But bottom line is everybody needs to be careful out there on the roadways. Wanted to ask you about something that has become an issue that maybe those of us who don't have children who have some sort of disability, we're not aware of this, but certainly parents of children with disabilities are, and that is planning for their future, especially when it comes to estate planning, setting aside the funds and the resources that are going to enable those children to continue to lead their lives and be cared for after mom and dad are gone. And that's, I know, something that is a burden on parents that I can't imagine how big that burden is, but I know that it must weigh them down considerably. So let's, if we could, discuss that a little bit.
Absolutely. This is a giant issue. And you're right, a lot of parents who have children with special needs are in tune with this to the extent that they realize they need to do some special planning to ensure that their children are going to be provided for appropriately when they're gone. But there are a lot of families out there that don't realize it as well. So I think it's really important to talk about. So let's just lay out the problem, and then we'll talk about a couple different ways that it gets resolved.
Okay.
The problem generally is that when you have a child or another relative or loved one that has a special need, has a disability, and they are obtaining government benefits, or it appears that they will be eligible for government benefits well into adulthood, such as SSI, monthly income to live on through the Social Security system, or very importantly, Medicaid, that their medical care is going to be provided for by the government. When you have a situation like that, if you are making an estate plan and you gift a portion of your estate directly to that child or that person, they may very likely will become ineligible for all those benefits. So when you think about the impact that could have, that a direct gift could have on, you're trying to provide for them, trying to do the best thing you can, and you leave them, portion of the estate, say it's worth $100,000, and that causes them to lose their medical benefits. That is obviously a terrible outcome, because the costs of medical benefits, particularly for some of these folks with disabilities, are very, very high. So what can we do to resolve that? That's the problem.
Mm-hmm. That's something you have to get out in front of rather than have to react to something. You would much rather have it taken care of right up front.
Absolutely. So there are several different things you can do. The first, let me just say that broadly, all of these things are commonly referred to as special needs trusts. Okay. And what it does is it creates a legal vehicle, a trust, to hold funds on behalf of this disabled beneficiary. It appoints a trustee to manage those funds, which can be a relative or a friend or even a bank or other financial institution, and it can provide for the disabled person, pay all sorts of expenses for them that they otherwise wouldn't be able to do. It can even, things like education and even costs of living and vacations and all sorts of things that they otherwise wouldn't have access to funds for. So, but it has to go through a legal vehicle such as a special needs trust. And most often what we're dealing with are what we call third-party special needs trusts, where we actually create this trust within the estate plan of the parent or the other person who's gifting these funds as part of their estate, and you create it right up front so that whenever the person passes away, whenever the person who's creating this estate plan, whenever they pass away, those funds go directly into this special needs trust. They never touch the bank account. They never touch the hands of the disabled person, so the government cannot disqualify them for benefits.
Okay.
And so, that's most often what we're dealing with is a third-party special needs trust created in a will or a standalone trust as part of someone's estate plan.
Now, that has to do, of course, with the financial resources that are going to enable them to receive continuing care. There have to be other issues that moms and dads are wondering about and hoping that they can take care of before that eventuality, too. What are some of those other issues that parents might want to consider?
Well, from this financial perspective, like I said, the maintaining of the government benefits is hugely important.
Yeah.
Now, also in tandem with that, okay, like I said, you're going to appoint someone when you're creating a special needs trust as part of your estate plan. You're going to appoint someone as a trustee, and often this is maybe the disabled person's brother or sister or aunt or uncle or trusted friend or other relative, or a financial institution. But when you're dealing with appointing a loved one as a trustee, you also need to think about, okay, is that person appropriate to also kind of be the guardian of the person with special needs, the disabled person, whenever I'm gone, and we need to make some arrangements for that as well.
Yeah, in fact, I would think that you would have to put several layers in place there of trusted people, and hope that you can find the correct trusted people that will be willing to take on that responsibility, because that would be something that they would have to agree to do. And then if they were to pass on before the disabled person, then there would need to be yet another person in line to step up. And so I know moms and dads, they want to do everything they possibly can to really be sure that after they're gone, their children are going to be cared for.
Right, absolutely. And those types of contingencies and that detailed planning, it goes into, to some extent, it comes into play with every estate plan we're creating, deciding on executors and powers of attorney and trustees and these things. And when you're talking about a disabled child, it becomes obviously magnified, and we really want to be careful about who we're putting in place, what that we have the right alternate people in place, and absolutely that communication that you talked about is key. In all situations, of course, you want to talk to somebody and say, hey, thinking of appointing you as the power of attorney in my estate plan. Let's have a discussion about that. Is it something you're willing to do? But when you're talking about appointing someone as a trustee of a special needs trust, someone to take care of a severely disabled child when you're gone, again, it's totally magnified, and those discussions just are really, really, really important.
All right, I want to go back to the trust, which is where we started this conversation, because I feel that we probably need some more guidance into not the need to set them up. You've already established that, but then how that moves forward and how you as an attorney would guide people through that setup. Right,
absolutely. So it's very important to do it up front, as you mentioned, because you can be, I think your word was reactive. You can be reactive about it, right? So if you have a disabled person that comes into an inheritance or a lottery winning or some other windfall, you can set up a special needs trust after the fact, but the problem with that is that it's much more strictly regulated when it is actually the disabled person's funds that are being placed into trust. And when the disabled person eventually passes away, any money left in the trust has to go to pay the government dollar for dollar any Medicaid benefits that were provided to the disabled person. So being reactive about it has severe negative financial consequences. So you've got to be proactive. And as far as guiding someone through this, not only working with the parents or whoever is setting up, providing the funds into this estate plan, when the time comes, working with the trustee, say, okay, this is how we're going to set this up. We're going to set this special needs trust account. Who's going to be the signer on the bank account? How are you going to decide when you can write checks from this account, and what are qualified expenses that you can pay on behalf of the disabled person? It's really important to make sure that you're only providing funds to pay qualified expenses, and so you want to consult with a lawyer about that. Have someone to guide you through it, so that you don't inadvertently reduce or remove the person's government benefits.
One of the interesting things to me about this whole discussion is the attorney himself or herself who would have this brought before them probably would want to research, okay, what will be the medical needs, the housing needs, all of the different needs that this person's going to have. So maybe mom and dad aren't thinking of everything right now, and I can suggest this or that to them. You probably, and I'm not thinking that this is just in this case alone, but in most cases, you have to have a working knowledge of what some of the issues are when these issues come up.
Every situation is different. Every situation is different, and when you're doing these plans, particularly the special needs planning, you have to get the clients to, that they're already thinking, well, how do we plan for our child's future? But you have to actually get them to look into the future and kind of visualize. Okay, right now your disabled child lives with you. A lot of cases that's true. Okay, your child now is living with you. What is going to happen to that child when you're no longer here? Let's look into the future and say, okay, what is the likely scenario, and work from there. So it's really it definitely takes a lot of work and a lot of planning.
Absolutely. All right, so someone wants to get started on this. They do want to get started right away. So, Marshall, what do they need to do to get in touch with you?
You can give me a call at 724-465-5826. You can always stop and see us in the R&P Cole Building, which is at 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
He is Attorney Marshall Chriswell. Thanks for being with us again today.
All right. Thank you, Todd. Take care. Have a good week.
You too.
Take care. Have a good week.
You too.